Yes.
Any mentioning not in the list? Any mentioning in the list?
No mentioning. Call the list.
Item number 1. Here are 11 of 23.
Yes.
Any mentioning not in the list? Any mentioning in the list?
No mentioning. Call the list.
Item number 1. Here are 11.
Or is it repeating? No mentioning. Call the list.
Okay, not today.
Or is it repeating?
Item number 2. Here are
For the petitioner, saying,
No mentioning.
my lord, I would pray that this matter may be taken up today because the other co-accused petition for discharge is pending for the court below. Assailing the order of the learned session judge, I have come before this honorable court. My part may
Let's
be heard.
start. Let's
My
start.
part may be heard, my lord.
Yes, let's start. So let's start. You take the note. Okay, you take the note of the argument.
I get the instruction, getting the instruction.
What instruction?
Maybe
The-
she'll be having something to submit to us. Because I don't have any local standing and she is appearing for the state.
I would request, my lord, this matter may be kindly taken up today because,
Okay, okay. Let it be passed.
my lord,
over.
I'll not sign in the way if it is
Okay,
passed.
okay. Let it be passed it over
I'll not-
for a while.
My lord.
Okay. Next.
item number 3. WPS 798 of 2023.
Lordship, I am for the petitioner, Lordship.
For the respondent type.
Lordship, on the last date, a order was given by the honorable court that the records be maintained with the petitioner and the records maintained with the respondent bank be ascertained. The petitioner is out of station. He has went to mainland for his mother's treatment. I pray for this instant case to be his next week, Your Honor. Next week on Tuesday, Your Honor. He is coming back on Monday. Some documents were given on the last day of the circuit. So this honorable court has said that you go and tally with the same with the respondent bank. This is a case wherein Lordship and loan of 8.5 lakh was given to the petitioner.
I understand, but so what is your submission? You have got the statements.
The petitioner is out of station, Lordship. He has went to Chennai for his mother's treatment. He's coming on Monday. But I pray this matter fixed on Tuesday, Lordship, Tuesday.
Please take down. On prayer of the learned advocate for the petitioner, the matter is adjourned today. This is the matter on which day? 12. 7.
17, Lordship.
That is the October. 17th.
I'm grateful, Lordship. Highly grateful.
7.
Item number 4. WPA 894 of 2023.
Your Lordship, I am for the petitioner. Here, Your Lordship, my reply is ready. Opposition has been filed. My reply is ready. Today in the registry, we will be filing the reply. But at the same time, I'm also filing an application for addition of party. The reason is that there are two private parties, because the authorities, what the authorities used to do, they have rationalized the distribution of cane products.
Cane product.
Cane products. They have rationalized and they have decided to distribute it equally among the units.
Okay.
That was going on for last more than 12 years. Suddenly they have changed the policy and they have said that where the unit is there, in that particular jurisdiction, whatever the production is there, it will be distributed among the units of that division.
Okay.
So unequal distribution has taken place. So due to that unequal distribution, two persons will be affected. If I succeed in the writ application, they will be affected. So I am praying that this matter will be taken up on Monday. By that time, Your Lordship, my application also will come up for hearing for addition of party.
Okay.
And a reply also will be on record.
Please take down. On the prayer of the petitioner
Navlendra Kumar.
for filing a reply along with an appropriate application, appropriate application. Let the matter be adjourned today. Release the matter on 16th. Enabling the petitioner to file reply and proposed applications.
Monday, Your Lordship. Item number 5. We are on of 122.
Lordship, and senior is here being the bidding for the state. I'm paying for a short password as she is engaged before. Item number 5 and 6.
This is the state appeal.
Item number 5 is state appeal.
Yes.
Item number 6 is appeal against conviction.
You want passover?
Yes. Yes. Please on that before court number.
Okay. Passed it over. Both the matters.
Item number 7. We are on 16 of 123.
Item number 7, my lord. Service is not yet affected, my lord. So let the matter may be posted to next Monday. So we'll, in meantime, we'll file.
Within next Monday, can you possibly have?
Maybe, my lord, we'll try. If it is possible. Always will.
Learned advocate appearing on behalf of the petitioner submits that the service is not affected till today. The service is not affected till today. So he requires, he sought for some accommodation. He seeks some accommodation. Some accommodation. And the matter is urgent today. This is the matter on 17th. 17th.
Always, my lord.
Item number 8.
My lord, I am appearing for the petitioner. My lord, in this matter, one of the advocate, Mr. Midgo Rai, will be appearing for the petitioner. I pray this matter may be taken up day after tomorrow.
Petitioner is seeking adjournment for not day after today.
Day after tomorrow.
Day after
12th,
tomorrow.
on 12th lots.
Day after tomorrow, that is means 11th, 12th. 12th. On the prayer of the petitioner. Matter is urgent today. Please the matter on 12th.
Obliged.
Item number 9. CRR 18 of 2023.
My lord, I am appearing for the petitioner, my lord.
Yes. Which for the state?
I have served the copy to Mr. Salim Mohammed. Now number.
Telling you. Lordship, since the learned council is not keeping well, so I just pray for the next week, your lordship.
Next week or day after tomorrow?
Let it be day after tomorrow if he's coming, my lord. My lord, in this manner, all the matter cannot be.
Informed that he's not keeping well and he has undergone an
But London
open
can
heart
do, na?
surgery. I have not been assigned with the treatment. क्या है matter out of the paper.
Okay. Very well. Not this week.
Item number 10. Here 45 of 2023.
My lord, I am appearing for the petitioner.
So Ajay Kumar is appearing for the respondent, my lord. He has undergone a.
Private respondent.
Isn't a,
Yes, private
Respondent.
respondent.
Right.
Respondent, only one
Only
respondent.
respond.
but he has undergone a surgery, my lord. The ligament. He called me to adjourn it to next circuit
Last circuit also same.
because he has not able to walk well. हाँ, कल आ गया, कल आ-
It is submitted on submitted that the learned counsel appearing on behalf of the opposite party is undergoing surgery. So it is not possible to take up the matter today. Considering the submission of the parties, the matter is adjourned today. Let the matter is adjourned today, let the matter appears on next available circuit.
Item number 11. Here 48 of 2023.
I am there for the petitioner. Yes. Who are the plaintiffs. The prayer is very innocuous. Suit could not reach its logical conclusion just due to the act of the other side. Some of the defendants filed written statement and the substantial difference have not filed written statement. Order 8 rule 1 time lapse. That grace period under 148 CPC 30 days that lapse not kindly see. I want an expedient disposal of the suit. It's a partition suit. Nobody will be loser and nobody will gain. I'm not knows partition suit decree. Everyone's right to be protected. But the suit is protected like anything. Now, kindly see the orders, certified copy of the orders. I'll just take my lord to the order at page, the order number 49. Right from order number 49, it's fixed for filing written statement by some. Only, my lord, written defendant number 1 and 2 are contesting the suit. They have already filed their written statement. 1 and 2. But other defendants are success in their act of dragging the suit, my lord. Some time-bound direction. Otherwise, my lordship, it would go on. And my lord knows the position of Andaman, my lord, where here civil suits take time. At least partition suit, my lord. Other suits I can understand, but partition suit, as I've been saying, my lord, rights would be determined in respect of both the parties with the intervention of court.
No, what is the last order?
Last order, my lord, would find it's an order dated 24/7/2023, fixing 13/9/2023 for filing WS. Even on that date, no written statement were filed, except 1 and 2. Others are dodging the issue. Some time on direction, my lordship.
File WS for what? Or who are the?
1 and 2 have already filed. I have said in my paragraph 2, the other defendants have not filed, and they have been granted liberty. And against some, the suit is proceeding ex parte. Against defendant number 3 to 6, Your Honor, my lord, kindly see order dated 10/3/2014. 10/3/2014. Against them, suit is proceeding ex parte. 10/3/2014. My lord, just I'll show. It's order number 6, my lord. At the bottom. London advocate petition plaintiff and defendant number 2 files SR received SR showing service upon defendant number 1 to 6 showing show cause. Defendant number 1 entered into appearance and file W. Copy served to the other side. Defendant number 2 files petition praying time to file ground stated therein. Petition is heard, considered and allowed. Defendant number 3 to 6 are absent without steps. None appears. Let the suit proceed ex parte against defendant number 3 to 6. As against 3 to 6, the law will take its own course. But as against other defendants, except defendant number 1 and 2, Lordship, they have not filed written statement. Some stringent order needs to be passed. Otherwise, this would go on, my lord. Lord, kindly see the plaint. It's a partition suit at page 10. And as I've said, my lordship,
Filed in the year 2013,
13.
10 years.
10 years, 1 decade lapsed. Those 2 years, my lordship, COVID period, that thing can be taken into account, but 8 years have gone like anything. Just at the same stage. It's stacked at the same stage, filing written statement. There are other stages to be undergone, my lordship, issues, discovery inspection, SGPH, PH. It may, if this be the conduct, my lordship, another 10 years it will take, my lordship, to see the color of the judgment. Just some time-bound direction. Nobody would be prejudiced, my lordship. I've served it. I filed the affidavit of service also, my lordship.
Yes, sir.
Yes, my lordship, it's there on record. Not kindly say affirmation has been made.
What is the affidavit of service? Okay.
It's in the filing office. Okay. Normally we file in the office service. This can be checked up, my lordship.
No, whether you have filed it.
It has been filed in the office, registry. My lord wants the copy, I can, because it's taken tomorrow, I can get it that the service comes on record by tomorrow, but it has been filed.
I'll check.
My lord.
Who is defendant number 7 and 9?
7, 8, and 9, my lord. Sultana Begum, Shabnam Begum, and Abdul Nazim. They are the defaulter. They have not yet filed the written statement. Just because of them, the suit could not be pushed to the next stage, my lordship.
Yes. Okay, please take down. Learned advocate, Mr. Chairpal, learned advocate, appearing on behalf of the petitioner, submits that the service upon the opposite parties has been affected, and affidavit of service has already been filed with the department. Stop. Or the learned advocate, none appears on behalf of the opposite party. Stop. Or the learned advocate. Very innocuous prayer was made on behalf or the learned advocate for the petition. A very innocuous prayer was made on behalf of the plaintiff petition.
Petition paid.
It is the submission of the it appears that the present petitioner is the sole plaintiff who filed a title suit being numbered TS 134 of 2013 before the learned civil judge, senior division.
Yes, Port Blair.
Port Blair, Andaman and Nicobar Islands. Stop. The suit was filed for partition and recovery of policy. Stop. Though the 10 years has been elapsed, but the suit was not progressed effectively. That's why the instant writ application was preferred for a necessary order for expeditious disposal of the title suit. Order for expeditious disposal of the title suit. Stop. Or the learned advocate, it appears from the certified copies of the order passed by the learned trial judge that the date was fixed for filing WS. Stop. It is surprising to note that though 10 years has already been elapsed, but no substantial progress has been made for disposal of the title suit. Accordingly, I think it necessary to pass an appropriate direction upon the trial judge to dispose of the suit as expeditiously as possible. Stop. It appears that the order of expeditious disposal shall not prejudice any of the parties to the suit. Considering the same, the learned Civil Judge Senior Division, Port Blair, Andaman and Nicobar Islands is directed to dispose of the instant suit within the year 2024. Yes, 2024.
Well,
Here is disposed of, along with connected can applications is pending are also disposed of. As the affidavit proposition is not used, so the
yes, yes, allegation. Deemed
allegations
my lord,
made
my lord.
in the
My lord.
made in the petition itself is not taken to be admitted. Stop.
Just only one indulgence, Lordship. Request be made to the registry to communicate the order to the trial court.
Okay.
Lordship.
Now, you are taking this order today itself?
If I get today, Lordship, the server copy is accepted and acted upon,
Okay.
but if it is sent through registrar.
Land register, land register is directed to communicate the order to the land trial judge through the land district judge,
No.
through the land district judge Port Blair, so that the direction of this court may be implemented through it, through letter and spirit. Through letter and spirit.
I'm grateful.
In this, my lord, I am for the petitioner. I am for the
Yes.
petitioner.
Before my brother starts, my lord, the order dated 29 September 2023 may kindly be seen. I have not been served with the copy. There is a direction to serve a copy to me of this civil division. This has not been done.
This may be taken up tomorrow. I'll serve this day.
Instead, tomorrow day afternoon. If they give
Let
the
it be
copy,
tomorrow, because I'll give in the day, course of day, within half an hour, I'll give the copy. Within half an hour. I'm extremely sorry. I'm having a copy. I'm just handing over it right now.
Okay, okay.
tomorrow it can. be-
Tomorrow it can.
Tomorrow?
Tomorrow.
Very,
Jafar sir.
not today.
For the-
Item number 30.
Application for disposal. 2011, this suit has been filed. First one, preliminary degree, final degree has been passed. Thereafter, again another suit has been filed. From 2011 to till today, not even not a single suit has been added. Rather, not been seen. I have been a senior citizen, not 89 years old. I'm not able to enjoy the degree, final degree passed on earlier around of the.
Have you served?
I'm there for one,
Okay.
OP number 1, Itwa Kachap.
The sole plaintiff, not.
And you are petitioner?
I am for the defendant number 1, not the suit and petitioner here.
What my brother is saying is not based on record. The suit has not even matured. My brother is saying that I have not started my evidence. Not kindly see the order sheets. It has not been ripened at the PH board.
So, Lord, it is 2011.
No, that's right, that's right. We were filing interlocutory applications.
After 2 years, they filed the refer to SOPA. I take the notes of the relevant orders. And subsequently, I filed an application for order 26
For what?
for commissioner. Lord.
Investigation?
Yes, Lord.
Then it will take time.
So that's also pending from 2019. Not 3 years. Lord.
Whether the petition was disposed of.
No, my Lord. It's not been taken for hearing.
You are the plaintiff.
I'm the sole plaintiff.
You are the sole plaintiff.
Yes.
And the petition was filed on behalf of the plaintiff.
No, my Lord, it is going to be defended.
No, the petition filed under order 26 rule 9, I think.
Filed by the plaintiff hearing.
Yes, filed by the plaintiff.
No, no, it should be wrong. It's filed for-
Order number 48. That is the last page of the certificate copy. Order number 48. Today is fixed for hearing.
Today is fixed for hearing.
Filed by the plaintiff.
It's filed by the defendant.
You filed the application.
Yes, ma'am. So there is a preliminary degree, final degree. I have given me the possession.
What about the merit? So you want the expeditious disposal.
Expedient disposal of this because it is an evidence. In 2011, we are in 2000.
You have filed the application under order 26. How can the suit be disposed of?
That application at a time.
Then you not press it.
That will be recorded. Lord. I will not press and an expedient date will be.
No,
disposal.
you take the proper steps before the learned trial judge, not pressing the document, not pressing the application.
2019, the case is still pending. Either it comes to a logical conclusion. The application not been heard. Even they are not filed.
No, you cannot prefer an application before the learned trial judge for investigation. And it is still pending and you are before the honorable court that the matter can be disposed of earlier.
Why? Because the reason is not 2019 till today, it has not come to a logical conclusion. They are not filed any opposition to that also. They're dragging up this. They are holding the possession. And that is why I oppose this court. There is time for manner be given, at least that application orders that will be disposed of. Trial court can dispose of that application for the commission.
My lord would see the order sheet the day when
The file written objection.
Lordship, for few days, for want of presiding officer, the matter could not be taken. For few days, they sought time.
No, we are-
I have also took time.
we are not-
The substantial time has been consumed by the defendant.
So what is the next date?
No, it is 4/9, I think. The next date, that's not to them, I ascertain the date.
Either they can have an order from this court to expedite order 26 rule 9. If they want the suit to be decided, not press there, come again an application. That may take time. The choice is up to my brother.
Yes.
As Lord has taken, I just pray that the application which is I have filed for the commission may be expedited. That will be a
Yes.
time for when it can-
Okay, that's.
Yes. That can be done.
I think you have no objection.
I will file my written objection there. A date be fixed, Lordship, within which the application has to be taken up. I will use my written objection in the meanwhile.
Very
The trial court can apply the minor Lordship as to the application.
Very good. Instant read application was filed for expeditious disposal of the suit title suit pending before the learned civil judge senior citizen at Port Blair, being number PS 231 of 2011. 231 of 2011. Next paragraph, learned advocate appearing on behalf of the petitioner. Who is the petitioner? Is the defendant number?
One is not in this case.
Defendant number 1 before the learned trial judge submits that an application was filed by the defendant petitioner hearing under order 26 under order 26 rule under order 26 of CPC praying for local investigation of the suit property. The same application is still pending. It appears that the pendency of the application for local investigation within bracket under order 26 rule 9 CPC. Order 26 rule 9 CPC. 9 CPC. CPC is the ground for pendency of the instant suit. At this juncture, plan for the petitioner submits that necessary direction be made upon the learned trial judge so that the application under order 26 rule 9 may be disposed of expeditiously. Disposed of expeditiously. Stop. Learned advocate appearing on behalf of the sole plaintiff. Respond opposite party number 1 hearing. Stroke opposite party number 1 hearing submits that necessary direction may be made so that the may be made so that the present opposite party may be given an opportunity to file an written objection against the said application. Written objection against the said application. Stop. At the learned advocate peruse the certified copy of the orders passed by the learned trial judge. The suit was filed for partition. The disposal of order 26 rule 9 CPC application is required to be this application under order 26 rule 9 CPC.
The disposal of the order 26 rule 9 CPC
Is necessary for the final disposal of the suit itself. Considering the same, learned Civil Judge Senior Division Port Blair is directed to dispose of the application being order 26 rule 9 CPC within the December of 2023. Stop. The present opposite party number 1.
I'll use objection in the meanwhile.
That is plaintiff is at liberty to file written objection against the said application before the learned trial judge. Stop. The learned trial judge. Next one. The learned trial judge, after considering the application as well as the objection filed by the plaintiff, stroke the present opposite party number 1, shall dispose of the application according to the law.
Without influence to any of the findings.
Without without influence, without being influenced by any of the findings of this court. Findings of this court. CO disposed of. Can application is pending are also disposed.
one time the order will be communicated to the lower court.
Okay.
Facing that.
Through registry. Through registry যে অর্ডারটা করেছি আগের যে অর্ডারটা করলাম হ্যাঁ প্ল্যানেট রেজিস্টার পোর্ট ব্লেয়ার প্ল্যানেট রেজিস্টার এটা আছে ডাইরেক্টর হ্যাঁ ভিজিট করেছি কমিউনিকেট থ্রু ডিস্ট্রিক্ট জাজ নেক্সট
Item number 14, WPS 60 and up
Lot 14 and 615 are the two matters out of 4 which are before my lord. The two other matters before court number 1, I made the submission in terms of other side, which Arun was there. These matters needs to be delisted so that all the 4 matters, identical question of law and facts have been raised. Just to avoid conflict in diligence, it has to be delisted. I would include these 2 matters along with those 2.
Yes.
Delisting has to be done. 14 and 15.
Yes, my lord. Let both the matter. Please take down. একটাই অর্ডার করবেন let the be out of the list, we go out of the list for we go out of the list for listing the same. Go out of the list. We go out of the list. For further listing the matter with the other connected matters before the learned first bench.
100.
Obliged, my lord, sir.
Same order in 14 and 15. Separate order.
Item number 16.
Lordship, I appear for the petitioner in this matter. The official respondents are duly represented by the council, but the private respondent was not appearing and I was directed to serve copy. I've served the copy which has been received back by me with the remark that insufficient address. So I'm required to reserve the private respondent.
Yes, yes. Give me the papers. Please take down. Liberty is given to the petitioner to serve upon the private respondents again. Petitioner is at liberty to mention. You may mention it.
Lord,
Petitioner is at liberty to mention. Private respondents. At liberty to mention.
Item number 17. WK 949 of 2023.
My lord, I am for the petitioner, my lord.
Yes.
My lord, this is the electricity matter, my lord. My lord, I have included a piece of revenue, government revenue land, and have constructed a house.
Yes.
Similarly, I have applied for the electricity connection to the concerned authority. And I have applied on the, kindly come to page number 8, sorry. Page number 9, my lord.
Page number 9 is the your Aadhaar card. No. Yes.
This
Your
application,
application is page number 10.
10, my lord, yes, yes.
So what is your application for getting connection
Electricity connection, my
or
lord.
electricity connection? So what happened there?
They have neither reject, they have neither connected and they have neither provided the electric connection. So according to the large and bench judgment, I am entitled to get the electricity connection, my lord.
Who is the authority?
Not they are appearing for the electricity department.
Who is the authority? You are for the?
And for the electricity department for conferring to the both the respondents there, 1 and 2.
1 and 2.
Yes. We will consider their case in terms of the other than judgment.
কি আছে? হ্যাঁ?
Copy.
Yes.
If we found in the certain position, then being a service provider, we will provide electricity. Terms of matters and conditions.
So a superintending engineer has to take the decision.
No, the assistant engineer is a competent.
Assistant engineer is competent. So he has to take the decision. So you take the decision according to the direction of the, in terms of
If
the,
he covers,
That's
then we
it.
provide the electricity.
yes. So I'm disposing of it.
Yes.
today. Please check down. The petitioner has filed an application for getting electric connection before the concerned authority on 29th of May 2023. It is the submission of the petitioner that his application was nor turn down, neither turn down nor neither turn down nor allowed, and no intimation was provided by the authority concerned. No intimation was provided by the authority concerned. Accordingly, the petitioner is before this court for necessary direction upon the authority. Learned advocate appearing on behalf of the respondent submits that the larger bench of this court in the larger bench of this court has decided the matter effectively. So necessary decision has to be taken by virtue of the larger bench decision. For the learned advocate, peruse the applications as well as the connected documents. As well as the connected documents. Also peruse the decision of the larger bench. Passed on February 11, 2011. Stop. Accordingly, the assistant engineer, electricity department, that is the respondent number 2 herein, is directed to dispose of the application filed by the present petitioner in terms of the direction of the larger bench within 4 weeks. Within 4 weeks positively. Stop. And the decision must be communicated to the stop. After the disposal, the decision must be communicated to the petitioner within 2 weeks thereafter. Stop. Accordingly, the instant CO is disposed of.
But the allegation contained in the petition is
Okay. Accordingly, no. As the affidavit was not used, as the affidavit in opposition is not used, thus the allegation made in the writ application is taken to be not admitted. Taken to be not admitted.
Obliged.
Next. Number 18, WPA 962
My lord, I am appearing for the petitioner, my lord.
And I am for the respondent, my lordship, led by Mr. Vedishwar.
My lord, here, the petitioner's father was the recorded tenant, my lord. During his lifetime, he has obtained a approval building plan from the municipal board. He has constructed a building. Thereafter, he has mortgaged the property also. Thereafter, he has expired. Now the legal has, after the expiry of the father, legal has applied for the mutation. They have applied on 17/11/2022. Thereafter, they have given this reminder also on 16/1/2023. Thereafter on 24/8/2023, but there is no action by the authority. So I want a direction upon the Tahsildar to demarcate, to mutate.
Why are you not taking the steps?
It can be disposed of, my lordship.
More than one, it's going to be 1 year, my lord. The petitioner is. Representation starts from page 19, my lord. Page 19. My first representation at page 19, my lord. On 17/11/2022, my first representation, my lord. On 17/11/2022. Thereafter, next page, my lord, page 20 is the reminder. 16/1/2023. Thereafter, my lord, again
on 22nd. Again, I have given the reminder on 24/8/2023, my lord. But no steps has been taken, my lord.
So within December,
My lord.
within December,
Yes, ma'am.
okay?
3 months, my lordship, that will be convenient. Otherwise,
3 months is there.
3 months, my lordship.
October, November, December.
My lord.
We are first of the October,
Yes, my lordship.
okay?
Yes, my lordship.
So you have also, you have to give in an opportunity of being heard
Yes, my lordship. In accordance with law, it can be
in
disposed.
accordance with. Please take down. The instant writ application was filed by the petitioner. Against the concerned authority, seeking specific direction on the ground that an application for mutation was preferred by the present petitioner on 17th of 11/2022. 17th of 11/2022. Stop. Before the 22, before the Tahsildar Port Blair. Stop. Thereafter, several reminder was made to the authority concerned, but the authority has not taken any appropriate steps. So the petitioner is before this court for necessary direction. The respondent is represented. Stop. Or the learned advocate for the respondent. Considering the entire matter, the respondent number 2, that is the Tahsildar Port Blair, is directed to dispose of the application filed by the petitioner in the 17th of November 2022. November 2022, within December of 2023. Within December of 2023. Stop. The authority, expect the authority shall dispose of the application after giving an reasonable opportunity to the petitioner of being heard. Stop. After hearing the petitioner, the appropriate authority shall pass the necessary order according to the law. The order of the authority must be communicated to the respondents, to the petitioner within the January 2024.
Yes, ma'am.
Within January 2024. Upon such direction, the instant WPA is disposed of. As the affidavit of opposition is not used. Affidavit in opposition has not been used in this case, so the allegation made in the writ application is taken to be not admitted.
Obliged.
Obliged, my lordship.
Next,
Number 19.
I am for the petitioner, my lord, I have served the copy to the respondents.
My lord, I am for the respondent, my lord. There is a direction from the Honorable Chief Justice Bench to file an affidavit. My lord, I am seeking an extension for my lord filing that affidavit.
This is for the first time it is appearing. This first time you want any, this for the first time it is appearing.
No. So there, my lord, then there might be certain confusion in this matter. I'll take the instruction. I'll come back, my
come
lord.
tomorrow,
My lord.
not today.
You नहीं हो नहीं है दूसरा मैटर है वो मेजॉरिटी इलेक्शन मेजॉरिटी को चैलेंज किया गया वेट एग्रीमेंट साइन करने का तो विदाउट सिग्नेचर करेक्ट करेगा
My sale permission has not been granted. Rather, it has been rejected without assigning any reason. There should be some reason at least to justify why this information was rejected.
So let me come back after tomorrow, my lord, sir, after taking necessary instructions.
After so much of struggle, we obtain the no issue certificate, non-encumbrance, everything. And when we apply, we must get some reason at least why it was rejected. Simple denial saying that it has been rejected. I must know if there is some flaw or something like that.
Yes, what is your submission?
My lord, sir, I will take instruction, my lord. Let me come back here.
Day after tomorrow?
We can take necessary.
Do you want to use affidavit?
It is not required, you take
My lord, sir, let
instruction,
me
why
take-
it is rejected.
Okay. Very well, very well. On the prayer of the learned advocate appearing on behalf of the respondent authority, the matter is adjourned today. On the prayer of the learned advocate appearing on behalf of the respondent authority, the matter is adjourned today. List the matter on 12th.
Item number 21, WPA 957 of 2023.
Lord, I am appealing for the.
My lord, I am appealing for the petitioner. My lord.
Same order be passed, my lord, as my lord, does not pass with regard to the ethnicity matter. The largest decision with regard to provide everything to the council and coach. कौन सा item था?
मेरा 22 शुरू वाला वो हो गया ना
The application was filed on February 2023.
13th February 20, page number 19.
February
13th February 2023.
13 February 2023.
And page number 26, my representation application was rejected. Page 26.
रिजेक्ट के एनरोलमेंट करके नीचे होगा
Okay, authority to take decision within December. So on the previous matter, what is the item?
17.
17, yeah, same order. Only the date of application is 13th of February 2023. Date of application 13/2/2023. All will be same.
Item number 22, WPA 967 of 2023.
तुम्हारी कैसी है
Application dated 26th of June 2023. Same. As 17.
oblige madam
Item number 23, CRA SB 2 of 2023. Honorable item number 24, CRA SPL 1 of 2023.
Lordship, I appear for the appellant in this matter.
Yes.
Lordship, item number 24 needs to be heard first. The reason being that is the leave for appeal.
Yes.
That needs to be allowed, then thereafter the appeal may be allowed. Lordship, this leave to appeal was preferred from an order of acquittal passed by the learned judicial magistrate first class 2 in a case under section 138 of NI Act, wherein I was the complainant. The order impugned may kindly be found, rather the effective portion may be found on page number 57. Page number 57, Lordship. The ground was that I was not able to prove that I am the owner of the enterprise, namely AS Enterprise.
Yes.
Lordship, page number 57, the last para may kindly be seen. It starts with 14 here.
Yes.
Section 142 of the Act requires a complainant under section 138 of the Act to be filed by payee or holder in due course of the check. In the case in hand, the complainant has miserably failed to prove any nexus or connection by adducing any evidence whatsoever what the name the enterprise as the AS Enterprise is the payee, and the complainant could not claim to be the payee of the check, nor could he be the holder in due course unless he could establish that the check had been issued to him or in his favor, or that he was the sole proprietor of the concerned enterprise, and being so, he could not also be the payee himself and thus entitled to make the complaint. Mere statement in the affidavit in this regard is not sufficient. My lord, this particular fact was never disputed by the accused also, that I am not the owner of AS Enterprise. It was never disputed. Rather, there was no question in the cross-examination put to the complainant that he is not the owner of the enterprise, namely AS Enterprise. In my pleadings, I have clearly mentioned that I am the owner of the AS Enterprise, and moreover, the amount of money, the concerned amount was paid from the account of AS Enterprise to the accused, and thereafter, the accused also returned the same amount to the complainant to the same account in the name of AS Enterprise. To that effect, evidences were led. Now, the statutory presumptions are all in my favor only, that I am the holder in due course, and there is nothing contrary in the record, or nothing contrary came from the end of the accused also, that I am not the owner. Still giving a complete go by to the statutory presumptions which are in my favor, this particular order has been passed, acquittal order. And moreover, with respect to the ownership of AS Enterprise, annexure A1 may kindly be seen. In terms of section 391 CRPC, I have annexed the document, although this document was not given before the court below, because it was never disputed that I am not the owner of AS Enterprise. Annexure A1, page number 26 of my leave to appeal.
Yes.
It has been issued by the State Bank of India, where it clearly says this is to certify that Mrs. AS Enterprise, in bracket, proprietor Shri Shamal Haldar. Shamal Haldar was the complainant.
Yes.
In the court below, maintain the current account with State Bank of India, Rangat branch, which has been closed in the year May 2015. So it clearly shows that I am the owner of AS Enterprise. And this fact was never disputed by the accused as well. The cross-examination of my lord, before cross-examination, annexure A2 may kindly be seen. That is an adjournment petition which was filed by the accused on 12th of July 2016. In this adjournment petition, the accused has clearly mentioned that the accused intends to, para number 2 of the adjournment petition, page number 28.
Yes.
Here he has admitted that the accused intends to pay the check amount to the complainant within a period of 1 month from the date, and as such the petitioner prays for time. Why he will pay that amount if he has not taken that amount from me, or he has not issued the check to me?
And you have put the objected to.
Lordship, that objection was for adjournment, not the contents. I didn't want that matter to be adjourned on that day.
Okay, hard.
Lordship, my leave to appeal may kindly be allowed with the direction to file the paper book.
Please take down. This is a petition for special leave to appeal against the order of acquittal passed by the learned
Judicial
Judicial
Magistrate.
Magistrate First Class Second Court at Port Blair in CR case number 125 of 2014, dated, what is the date?
Dated Lordship.
29th day of December 2022.
Lordship.
This special leave was preferred under section 378 within bracket 4 of the Code of Criminal Procedure. Or the learned advocate peruse the judgment, impugned judgment and order passed by the learned judicial magistrate. Stop. I have also perused the annexures filed along with the leave application. Considering the services of the learned advocate, the leave, the special leave to file the appeal against the order of acquittal passed by the learned magistrate in CR case number 125 of 2014 under section 138 stroke 142 reduced section 140 141 142
142.
138 stroke 141 no 141 reduced section 142 of the Negotiable Instrument Act 1881 is allowed.
Oh, bless you.
Appellant is directed to serve the memo
Lordship.
Of
Lordship, memo has already been served. I have filed the affidavit, yes, affidavit of service also.
where is the affidavit of service?
Yes, on the earlier occasion itself.
Okay.
There was a section 5 as well.
Yes.
I served the copy of the section 5. I mentioned in my affidavit
Have
of
you
service.
served?
Yes,
Section 5 application,
section 5 also served.
that is can
Was served and thereafter,
CRAN 1.
Lordship. Can 1.
Okay, from the continent. No, got it. Can be stamped. Have you served the CRAN?
Can was served,
Memo was served.
memo was also served, and this particular special leave also was served.
Yes.
And I have filed an affidavit of service to that effect. It is there in the record.
Therefore, the affidavit of service filed on behalf of the appellant is taken under control. It appears from the affidavit of service that the memo of the appeal and including the CRAN application as well as the leave, special leave to appeal has been served upon the respondents. Stop. The affidavit of service also indicates that the service is sufficient. Considering the same, the is sufficient. Stop. Considering the same, the appeal is hereby admitted.
Deeply obliged.
Call for the LCR.
Lordship, direction may be given for paper books so that everything will be kept in one place. Consult.
Only paper book or the LCR is required.
LCR may also be called along with that.
There's a call for the SCR on the learned copy. Stop. The appellant is directed to prepare the requisite number of paper book. Prepare the requisite number of paper books within 8 weeks,
Within 4 weeks,
only within 4 weeks.
4 weeks.
Within
Sure.
4 weeks. Let the matter appear. No, you mentioned it.
As your lordship, please.
The appellant is at liberty to mention.
Deeply obliged. I'm grateful. Grateful.
Item number 25.
In this, my lord, I am for the appellant. This is an appeal against the conviction passed by the learned special judge Poxo, whereby the accused convict was convicted on 5th of September 2023 to undergo imprisonment for 4 years. And he was convicted under section 7 and 8 of the Poxo Act, my lord.
Yes.
trial court because all the.
Evidence witnesses are waiting, my lord, since morning.
Witnesses are held up. We'll start at 2 o'clock.
One matter was passed over, my lord. That can be taken up.
Yes. After that,
Matter number two.
after at 2 p.m. Who is there? Item number 2, this is Passover matter.
Now if it can be taken up 5 minutes, gladly taken.
Okay, call the matter. Call Passover matter.
Item number 2, CRR 12/2023.
The petitioner challenging the order of the learned session judge, I assailed this petition before this honorable court. My lord may kindly come to the order which is at page number 126. It starts from page number 126. Run down to page number 128, my lord. May I just place the backdrop fact of the case, my lord, for the convenience of this honorable court. What has happened, my lord? The de facto complainant, he made a written complaint before the SHO PS Aberdeen as well as to the SP South Andaman regarding the offence under section 376D. No FIR was chalked out. Being frustrated out of it, she lodged a petition under section 156(3) before the Learned Court of Chief Judicial Magistrate. The Learned Magistrate, after going through the contents, was pleased to direct the SHO PS Aberdeen to chalk out an FIR and continue with the investigation. My lord, the story starts from here. When she lodged a written complaint, at that point of time also there was an allegation against my client, the petitioner before my lord, is that she being a reporter or editor, she published her name in the social media, name of the victim girl. Thus, the offence is under section 228, capital A of the IPC, read with section 500 of the IPC. This was initially there in the written complaint. It was in the 156(3) petition also. The Learned Court gave a direction for FIR. What has happened, my lord? The FIR was chalked out in a single nature. 376D along with 228A and 500 of Indian Penal Code. Charge sheet was also filed clubbing this accused along with that particular prime accused persons. When the matter was committed before the Learned Court of Session Judge, I come out with a petition stating the fact that the offence as classified in the CRPC defines that this is a magistrate tribal case. And the case has to be split and then have to be sent back before the magistrate court so that I can take up my trial. There was only two reasons, my lord, to just kindly appreciate and to come before this honorable court. First ground was that, my lord, the section apparently appears against me is magistrate tribal. Law says that. I would like to take my lord to that particular portion of law. My lord may kindly have a look to section 228 capital A of the IPC.
In the IPC.
Got it, my lord?
Yes.
Disclosure of identity of the victim of certain offences, etc. Whoever print or publish the name or any matter which may make known the identity of any person against whom an offence under section 376, section 376A, section 376B, 376C, D and E is alleged or found to have been committed shall be punished with imprisonment of either description for a term which may extend to 2 years and shall also be liable to fine. Now, my lord may kindly see the classification column of the offence. The offence under this section is cognizable, bailable and triable by any magistrate.
Yes.
Now, kindly, my lord, may come to my annexure, which is at page number 22. Sorry, before that, my lord, kindly come to page number 19 once. This is the petition under section 156(3) of the Criminal Procedure Code 1973 before the Learned Chief Judicial Magistrate. Got it, my lord? Continue to that page number 22, my lord. Point number 13 from the top, second para. Moreover, Rupalal is the petitioner before my lord. Got it, my lord? Page number 22.
Yes.
Moreover, Rupalal, a self-claimed journalist, has directly revealed my name in a video released on 31st August 2022 in our YouTube channel, Nation Vision with Rupalal, and publicity did my character assassination with the assistance of Inspector Jagdishwar Rao. Next para, my lord. Inspector Jagdishwar Rao shared my personal detail to the local journalist, Mr. Rupalal. I'll pause this quote for a moment. But surprisingly, this Inspector Jagdishwar Rao is not the accused in any of the charge sheet. The allegation is very specific, my lord. I have not come for discharge before, my lord. To be very candid, my lord, I have not come for discharge. But the fact remains, the complaint says that some X has transferred this information to me. But that X is neither the accused nor the witness in this case. But I have been arraigned as an accused. I don't stand against that particular charge sheet, my lord, at this stage. But what I pray is 228A says, my lord, it is a magistrate tribal case. Now, if the matter is committed and tried by the session court, I am losing one forum of appeal also. In a case, if I take in a negative sense to this honorable court, that if I am convicted by the court, then I have got an opportunity of appeal before the learned session judge. Suppose if the trial is taken up before the learned session judge, because since the matter is heinous in nature under section 376D, I am losing one forum of appeal. Secondly, my lord, there are 135 witnesses cited in the list of witnesses, wherein only 2 to 3 witnesses related to me. I have to again wait for another 8 years to get this matter disposed of. Now, my lord, may kindly come to section 223 of the CRPC once. Section 223, my lord. Got it, my lord?
Yes.
What person may be charged jointly? The following person may be charged and tried together, namely A. Person accused of the same offence committed in the course of same transaction. I am not the same accused because 376D is entirely something different.
Yes.
A person accused of an offence and person accused of abatement of or attempt to commit such offence. Neither I am a abater under section 34 or 120B. Now, C. Person accused of more than one offence of same kind within the meaning of section 219, committed by them jointly within the period of 12 years, 12 months. Now, kindly, I'll pause this quote for a moment. My lord, may kindly come to 219 once, because it is a referred section under section 223. I would request my lord to kindly have a look to 219.
3 offences of same kind.
My lord, so this is not a same offence. It was a single offence of that particular year. FIR was chalked out and charge sheet was filed. So 219 has no relevancy, but then it was referred, so I took my lord to that portion of law. Now, thereafter, person accused of different offence committed in the course of same transaction. Person accused of different offence committed in the course of same transaction. This is not of a same transaction. Why can understand, my lord, if the allegation is under 376 for one accused, 354 against one of the accused, wherein we both were in the same room and I committed 354, he has committed 376. Here the offence is not like that. More so, I would like to emphasize before this honorable court with greatest of my respect, to the extent the complaint is categorically mentioned the name of one of the co-accused on my behalf, that he has shared the information to me. Till date, my lord, he has not been arraigned as an accused. Now, after filing of this revision, so I did not enclose those petition. Discharge petition from the prime accused was filed before the trial court. Argument was going on for that particular discharge petition. Investigation officer filed another petition for further investigation. Now, kindly see the fate of the entire case. Now, if the further investigation will go for 2 more years by the leave of the trial court, my lord, I being a lady, I being a journalist, I have to wait for the disposal of the entire criminal trial under section 376D along with the prime accused. And since I am blessed, since your honor was also in the trial field previously holding the chair of High Court bench, my lord knows, my lord, that the topographical and geographical condition of this island. To complete 135 witness, 135 witness, it will take, I with all dignity and respect to the court procedure, I say, my lord, it will take at least 6 to 8 years. Now, at this stage, wherein the trial or the section against which there is an allegation for me, my lord, it says magistrate tribal. I'll further take my lord to the section sorry, not the section, my lord, the classification table, my lord. My lord, may kindly come to in the CRPC first schedule, classification of offense.
Yes.
Kindly see section 228 capital A, my lord. Imprisonment for 2 years and fine cognizable any magistrate. Got it, my lord?
Yes.
Thereafter, my lord, may kindly come to second table of classification of offense against other law, my lord. Second table of classification, wherein it has been categorically mentioned, my lord, if punishable with imprisonment for less than 3 years or with fine only, non-cognizable, bailable, any magistrate. So the law is very clear, my lord. The law particular to the section, to the allegation alleged against me is specific and clear. And my lord, may kindly see the finding of the court below.
No, what application you have preferred with the law in court below?
For splitting the matter and remanding my matter back to the learned magistrate, since it is a magistrate tribal.
Or splitting the charge?
My lord, my lord. My lord, no, charge has not yet been framed. I prefer a petition prior to that to just split the matter and then my matter may be remitted back to the learned magistrate.
What is the observation?
Now, my lord, may kindly come to page number 127, last para.
Yes.
Since the involvement of the present accused is with the main offense and out of the same affair at this stage, without trial, it is very difficult to ascertain as to whether the present accused has any direct nexus with the other accused or not. I'll pause this quote for a moment. Why I really beg pardon to just differentiate with the order of the learned trial court. Why I say, my lord, kindly see, since the involvement of the present accused is with the main offense. My lord, my connection is not with the main offense.
Yes, I understand.
And out of the same FIR, my lord, FIR allegation was very specific. Learned Court of Learned Chief Judicial Magistrate direct the SHO abiding to chalk out an FIR. Never said that you club the same accused in the same FIR. It happens many occasions, my lord, that there may be one incident, but there are 4-5 accused with a different act. And furthermore, since witnesses of the case are correlated and if the case is splitted, the defense will be disclosed and the case of prosecution will be prejudiced. I beg pardon, my lord, the learned court below was a bit favorable to the prosecution. I beg pardon again. Because my lord, I beg pardon to make this submission. My sister should not step into the shoe of learned court below. Why I say, my lord, because the court has to be very neutral. If the court says that the defense of prosecution will be disclosed, to what extent I am asking myself? Because I am also conducting the trial from last 24 years. I even want to learn from my learned sister, even if she got so much of pain with my submission, that what was the prejudice about the accused who is facing a trial of magistrate court, but attending the trial before the session court, losing one forum out there. There are only 5 witnesses. I can name those witnesses, those who can say against me. And I have to wait for another 130 witnesses to get disposed of the matter for 8 years, my lord, and kindly see the other co-accused who was named in the FIR. Let the prosecution explain why his name has been taken out during the charge sheet. Because he was a police inspector. Because the complainant has categorically said that
No, it is So tomorrow, not after 2. Very good. Thank you.